Going on, I wanted to make my prior recording clear. And the reason why I want to make it clear is because I don't want people going off speculation. Okay. A lot of times people go off speculation and beliefs, and sometimes you need to read the instructions. And that's why I tell you read the instructions of IRS forms, because if you read the instructions of the IRS forms, there is no speculation. Okay, a lot of people tell you to use a Form 56. It's not the Form 56 per se that expresses a fiduciary relationship. You have to give notice to the other party. The Form 56 is the IRS's form. This is notice to the IRS. You're not in business with the IRS. You're in business with the other party. So you have to express your fiduciary relationship to them, not the IRS. Once they accept it, then it can be expressed to the IRS. Okay. There are other ways to do it. You can do it through conditional acceptance, etc. You can do it that way. But as a whole, read the instructions of the Form 56 so you do not speculate. It's a lot of people speculating on the internet. It's people telling people to revoke power of attorneys that don't even exist. Fam, read your agreement. If the agreement says that you give us a power of attorney, then you can challenge it then. If it doesn't say it, then they don't have one. Okay? Stop speculating. Okay? Start reading, start asking for intel, start asking for information so then you don't speculate and sound crazy. Okay? It's a lot of people teaching y'all to do a lot of stuff, and they're not telling you read your agreement, see if this is in your agreement, read your agreement, see if there's a security interest in the agreement. They can't have a security interest without compensating you. That's a violation of the security interest, and that's a violation of consideration. See, it's in your agreement. So don't speculate that you should do something because you heard someone on the internet or you read the instructions. So what we're going to do is we're going to go over the Form 56 instruction form, and I'm going to explain this to you. Okay. Some of this stuff that I'm going to go past because it doesn't matter. Okay. So first you need to understand what a fiduciary is. As I said, you always need to understand what the person is and what role they occupy. Fiduciary. A fiduciary is any person in position of confidence acting on behalf of another person. So we know that they are a fiduciary. Okay. We know that by what? You have an agreement. So if you have an agreement, they're a fiduciary. Okay. And so are you. So you have to decide who is going to handle what role, and that'll clarify your contracts, and it'll stop all of these headaches with you sending 50 million letters and them not listening to you. Okay. Stop making assumptions without having information and intel. Send a letter, request all of the accounting, all of the stuff that you want, and then you can actually, from there, form an actual letter that works. Even in the past, when I was trying to help people, I was like, instead of just telling them, take time, pause, breathe, and start getting intel on your account so you can actually make a claim. Most people just want to make a claim that moment. And that's one thing that I have to teach you guys. You got to kind of pump your brakes sometime. Stop acting off emotion and start acting off logic. A fiduciary assumes the powers, rights, duties, and privileges of the person or entity on whose behalf the fiduciary is acting. So that tells you if they grant themselves rights in the agreement, you have the same rights that they do. Got it? Because they had to get it from somewhere. They couldn't get it from the ether. They couldn't have made it up. So look, examples of fiduciaries include administrators, conservators, designees, executors, guardians, receivers, trustees of a trust, trustees in bankruptcy, personal representatives, persons in possession of property of a decedent's estate, or debtors in possession of assets in any bankruptcy proceeding by order of the court. Okay? A person is any individual, trust, estate, partnership. So if you have some of my older videos, that explains this. Association, company, or corporation. So if a corporation is in constructive receipt of your obligation, that means that they are a fiduciary. You just never sent them a notice, so they're acting as if you're the fiduciary. Remember, whatever you say in life, or when you say something in life, you have to be very specific about what you say. Decedent's estate. A decedent's estate is a taxable entity separate from the decedent that comes into existence at the time of the decedent's death. Okay. So what they didn't do is they didn't create a decedent's estate, they created a trust. Okay. All contracts, all agreements where somebody is holding something on behalf of someone else is a trust. I don't care what a lawyer tells you, it's the same. They function differently. They may not be specified as a trust, but they are a trust. It generally continues to exist until the final distribution of the estate's asset is made to the heirs and other beneficiaries. So when you're in an agreement, the maturity date or the consummation date is the date that your partnership severs. But if you didn't receive the proceeds, then that partnership is ongoing until you receive the proceeds from the agreement that you were supposed to. Terminating entities. A terminating entity such as a corporation, partnership, trust, etc., only has the legal capacity to establish a fiduciary relationship while it is in existence. Establishing a fiduciary relationship prior to the termination of the entity allows the fiduciary to represent the entity on all tax matters after it is terminated. Okay? So if you set up your agreement in a way that the other party you don't have a creditor debtor relationship, this doesn't really matter to you too much. It doesn't mean that you may not want to say, hey, can you make sure that you file this? But I would send it to them with a letter saying, hey, this is a notice of whatever. I'm not even going to tell you what to do. Okay, I'm gonna let you figure out what's in your best interest. So look, when and where to file. So it's right in here. Notice of fiduciary relationship. Generally, you must file Form 56 when you create or terminate a fiduciary relationship. Okay. So you can put notice to the IRS, but you have to notice the other party first because that's who you're in contract with. So once you're in contract or you send it to them and you create that relationship, then you can either have them send this to the IRS, or you can send it on behalf of them. But in my opinion, you really don't need a Form 56 as of yet. Like, not unless you're doing big numbers or you got a huge account or something. You don't really need that. Form 56. Let's say file Form 56 with the Internal Revenue Service Center, where the person for whom you are acting is required to file tax returns. Proceeding other than bankruptcy and assignments for the benefit of creditors. A fiduciary who is appointed, see, you have to appoint them. Once you appoint them, then you can say, okay, now you have to file a Form 56. They have to be appointed. Okay. That's what I'm talking about in the video, because a lot of people think, oh, well, I'm just going to send them a Form 56 that's going to revoke it, that's going to do this, that's going to do that. And it's like, fam, first of all, you don't even know if they filed the Form 56. So don't speculate. Please don't speculate. I had to learn this myself too, because sometimes I'll jump off the rails and I'll speculate, and we want to make sure that we're not doing that. Don't act off emotion, act off what you can prove. Don't, and all that other stuff, try to prove it in your own time, but don't act off emotion. A receiver in a receivership proceeding or similar fiduciary, including fiduciary in aid of foreclosure. So you can do a conditional acceptance or structure anything if you're going through a foreclosure and turn all of them into fiduciaries. I think I might show people how to do that because it's very simple. It's simple, and you don't have to disclose it to the public. That's really what y'all need to learn too, and myself too. Is stop filing documents in the public. So if you're really trying to get stuff done, you want to keep it in the private. And I know what I should be doing. That's what's worse. I know what I should be doing, and I still do what I want to, which is sad sometimes. So look, or an assignee for the benefit of the creditors. I think part of my spirit kind of likes a little friction sometimes. When you get with these people and they give you a little pushback. let's see, must file Form 56 within 10 days of the date of the appointment with the advisory group manager of the area office of the IRS, having jurisdiction over the person for whom you are acting. See, just by filing a Form 56, you get them jurisdiction. Oh my goodness. See publication 4235. See, people saying, oh, this revokes. No, the only way I can revoke it is if one Form 56 is filed, then you have, well, I'll get to the publication. I'll explain that to you. Collection adversary office's contact information. Okay. So some of this I'm going to skip over because a lot of it doesn't matter, but we're going to get to the meat of it. So first it tells you who must file a fiduciary. See definitions below. Who seeks to act on behalf of a taxpayer before the IRS or to inform the IRS that the fiduciary capacity has been terminated. So first you have to prove that there is a fiduciary aspect. Okay. So you can do this and say this is for any potential fiduciary responsibilities, but that doesn't mean it's going to terminate them because you have to specify what you're doing. You can't just send a letter, I'm terminating everything. That doesn't mean that the IRS is going to get it and they're going to act accordingly. That's why everything has to be specific. That's why you have to have proof, because if you're bringing something, you have to act like you're doing it in like a court case. Always act like you're going to court, even when you're not. If you send a letter to the bank or financial institution, take exhibits, treat it like you're going into court, even if you're not. And once you learn that habit, every time you send out a document, you're going to get more results than the other people because you're treating it as a court proceeding. All right, let me go back. Okay, so where was I at? Okay, must file a Form 56 to notify the IRS of the creation or termination of a fiduciary relationship under Section 609, 6903. So make sure you read it. Receivers and assignees for the benefit of the creditor also file Form 56. So if until you establish that you're the creditor, they're really not obligated to fill out a Form 56. So there's a lot of times where people have to understand what a taxable event is, what leads to a taxable event. Just because you're sued in a court case, that doesn't mean it's a taxable event. It's not a taxable event until you actually control the disposition of the proceeds. When you control the disposition of the proceeds, then it becomes a taxable event. So I'm going to finish this off and I'm going to show you what taxable events are under law. This is not speculation. You don't need to speculate. This stuff is simple. Don't make it complex. Don't create ghosts that don't exist. Okay. Receivers and assignees for the benefit of the creditors. Also, okay, I already did that. I'm gonna read it again though. Form 56 to give notice of qualification under section 6036. However, a bankruptcy trustee, debtor in possession, or other like fiduciary in bankruptcy proceeding is not required to give notice of qualification under section 6036. So when people talk about Form 56 forms, I'm like, please read the instructions because the IRS gives you instructions with every form. If it's a 1040, a 1041, a 1099 C, 1099 MISC, 1099 OID, 1099 INT, 1099B, all of that stuff has instructions. So you don't have to speculate. Okay. Trustees, etc. in bankruptcy proceedings are subject to the notice requirements under Title 11 of the United States Code, bankruptcy rules. Do not use a Form 56 if you are notifying the IRS that you are the authorized representative of the taxpayer. What do people tell you to do? Send a Form 56 to show that you're the authorized representative of the taxpayer. It says right here, don't do it. You know how many videos I've seen where people told people to do it? I just sitting there shaking my head. Instead, use Form 2848, power of attorney. Listen, they're telling you some powerful stuff. Listen to what it says. Instead, use Form 2848, power of attorney, and declaration of representative. So most of you guys don't know that you don't have to say, I'm revoking my power of attorney or revoking someone's power of attorney. You can create one. I was like, how many people know this? How many people have read this? Everybody on the internet is talking about Form 56s, but they're not talking about Form 240, 280, 2848. I don't really get into taxes. I know a lot about taxes. I just don't get into it. Look, a fiduciary is treated by the IRS as if the fiduciary is actually the taxpayer. Okay. Upon appointment, the fiduciary automatically has both the right and responsibility to undertake all actions the taxpayer is required to perform. For example, the fiduciary must file returns and pay any taxes due on behalf of the taxpayer. Authorized representatives is treated by the IRS as the agent of the taxpayer. So what people are trying to do is they're trying to have you establish agency. Okay, and you have to know how to properly do that to make sure that it's enforceable in if it has to get to court. Okay, the authorized representative can perform the duties authorized by the taxpayer as indicated on the form 2848. An authorized representative is not required nor permitted to do anything other than the action explicitly authorized by the taxpayer. So this is why I was telling you, you have to send them notice before you send notice to the IRS because they have to have notice, and that's where that 10-day window goes in. So that's why I'm like, you don't just send a Form 56 to somebody. You have to follow the instructions from the form. Okay, look, specific instructions. I'm not going to read it all because I will be reading forever, and I'm not, this is not reading Rainbow. So look, specific instructions, part one, identification. Provide all the information called for this part. If there's more than one fiduciary, each fiduciary must file a separate Form 56. So you can demand the banks and financial institutions fill this out on behalf of you. But you have to demand it and you have to show what capacity that you're operating that compels them to do it. Okay. So it needs the identifying number, decedents. So if you're acting on behalf of the decedent, either the decedent's social security number or ITIN shown on the decedent's final form, 1040, in the space provided. Okay. If you're acting on behalf of the decedent's estate, you must file a form 706. This is where Gene Keaton got this from because Gene Keaton, unlike most people, read the instruction. And I like his video. People are like, he's so crass, and I love it because sometimes you got to be like, you're an adult. I'm going to talk to you like an adult. And sometimes some people it'll shy people off, and some people will say, you know what, I am wrong. And once you accept that you're wrong, now you can move to being right. So we're not going to go over the nature and the liability of taxes because I'll leave this under the video on YouTube. So this is where people think that a Form 56 does a revocation or termination of notice. Okay. So this is section or part two because I've read almost all the instructions for all tax forms. I used to do that in my spare time. So look, part two, revocation or termination of notice. Complete part two only if you're revoking or terminating a prior notice concerning a fiduciary relationship. So you have to have proof that one was sent, right? So if you're revoking something, don't you need an exhibit or a copy to show? This is why a lot of people's letters don't hit. Even like I had to learn this. You got to send some examples. You got to show them why. You have to say this is why. This is why I'm telling you this. You don't just send stuff, because the law says this and you do this, and then they're looking at you like a child. That's why they don't respond. I had to learn that myself. I'm still learning. That's the beautiful thing about this because you're still a student. You can't be a master without being. So look, completing section B or C does not relieve any new or substitute fiduciary of requirement to file a Form 56 or to otherwise give notice. So as soon as you give them notice, they're supposed to file this. You're not supposed to be sending this to them. They're supposed to be filing it. Does it make sense to you now? So look, people go to court and then they don't understand. They just file a Form 56 in a court case, or they send a Form 56 to the judge. The judge's like, what the hell is this? You got to give people instructions. You have to talk to everybody like they're stupid, even when they're not. And when I say that, I don't mean be disrespectful. You have to explain things. Even me, I'm learning how to do that better too. I'm trying. So when you explain stuff, I try to explain it to a point where everybody can understand, but I know everybody's not going to understand it. It's too many people on YouTube. It's too many people on Instagram that watch this stuff. So look, part three, court and administrative proceedings. Complete this part only if you have been appointed a receiver, trustee, or a fiduciary by a court or other governmental unit in a proceeding other than a bankruptcy proceeding. You know what another governmental unit is? You. It says it in the Constitution. It says the government receives its consent from the governed. So that makes you a governmental unit. If proceedings are scheduled for more than one date or place, attach a separate schedule of the proceedings. Assignment for the benefit of creditors. If you have been appointed as the assignee for the benefit of creditors, you must attach the following information. Okay? So who says you can't appoint yourself as the assignee? Who said you can't? Appoint yourself as the natural person or give yourself an office. You can do whatever you want. You guys have to understand, take this information, study it, and just build your understanding for it. Don't believe, don't speculate. No. When you say something and you know it, it has more power than believing. R. Kelly believed he can fly. We see his wings kind of were a little clipped, but we're not saying that. So look, a brief description of these assets that were assigned and an explanation of the action to be taken regarding such assets, including any hearings, meetings of creditor sales, or other scheduled action. So, if you don't know what assets that you're trying to assign or take over, how can you take over them? Because you don't have a description. So, look, this is why I was telling people sign the Form 56. It has to be signed. Sign Form 56 under the penalty of perjury and enter a title describing your role as the fiduciary, for example, assignee, guardian, trustee, personal representative, receiver. So a lot of people sign as the personal representative, but they don't give themselves the authority to sign in that capacity on their account, meaning their bank account, etc. Receiver, conservator, surviving spouse, or sole heir in possession of the property of the decedent. So you could be the sole heir in possession of your uh, bank account. You could be the sole heir in possession of the car title or whatever you want. This really, once you start understanding this stuff, the basically the rules break away. Like when I did a consultation, I was talking about how the people think the UCC is so complex, and the UCC is really a cage for the corporations, but a freedom for the people if they know how to use it right. So look, when you understand what a taxable event is, and this is under Title 26, most of your taxation or tax codes are going to be under 26 USC or 26 CFR. I think it's 27 or 26 CFR. I forgot. I'm not looking at all of those citations and codes no more because I understand it better. So look, the taxable event. Taxable events for the purpose of this subsection. In general, the term taxable event means any of the following: the death of the transferor, if the applicable restrained interest conferring the distribution right is includable in the estate of the transferor. The transfer of such applicable retained interest, I'm sorry, at the election of the taxpayer. The payment of any qualified payment after, after the period description in the paragraph 2C, but only with respect of such payment. Exception to whether spouse is transferee, death time transfers, subparagraph AI, and not Allen Iverson, no, it's one, shall not apply to any interest includable in the gross estate of the transferor. If a deduction with respect to such interest is allowable under section 2056 or 2106, go read them, A3, section II, lifetime transfers. A transfer to a spouse of the transferor shall not be treated as a taxable event under subparagraph AII if such transfer does not result in a taxable gift by reason of I, any deduction allowed under section 2523 or exclusion under section 2503B or I think this is II or 2, consideration for the transfer provided by the spouse. Okay? So there is no transfer. There's no taxable event unless this happens. So a lot of times when people think that the court case creates the taxable event, it's not a taxable event until the liability is either transferred or accepted. Just to make all of this simple. The IRS makes this stuff complex for a reason because they don't want people to just sit down and be able to explain it like I'm explaining it and give it to you in a point where it's very simple. That's why people make law complex when it doesn't have to be. So the spouse succeeds the treatment of the transferor if an event is not treated as a taxable event by reason of this subparagraph. The transferee spouse or surviving spouse, as the case may be, shall be treated in the same manner as the transferor in applying this subsection with respect to the interest involved. And with that being said, as long as you know when a taxable event occurs, then you know how to do it. You can elect anyone in the public to be a trustee for you in regards to any transaction, but they have to accept it. If you can't just sit there and say, "Oh, you're my trustee," and force a person into it, come on, man. That's not unless you give them some sort of consideration. So if you give them some sort of consideration for their action and then they do it, then it becomes dishonor. That's why they send you a notice in the mail with a so-called bill and with a coupon on it, and then when you don't distribute the funds, they act as a notice of dishonor because they gave you an asset or they gave you an asset of consideration, and you haven't liquidated it or transferred or accepted this asset and did what you needed to do with it. And with that being said, man, I hope y'all have a great week. I hope you're productive, and if no one told you they love you, come on, man. Have a great one.